presented the parties with instructions 1 through 26, along with 2 verdict forms. There have been defense tendered instructions that we'll talk about. I did want to tell the parties that I did change number 19. I took out the words in the third line talking about the court's treatment of him, of his lawyers, or from. Basically what I was trying to do is not emphasize that I was trying to make it equal in terms of how I treated the attorney. So I de-emphasized the defense on that, and that's the only change to 19. There were some typographical errors from what you guys had. I gave you all last night, and I think there was a duplication on the theory of defense. So, Mr. Champagne, as to instructions that I've tendered 1 through, I forgot already, 26, do you have any further instructions to tender, any objections, or anything you want to say about them?
Judge, just that I think we're going to hold off discussion on number 7, but
correct.
We're just going to review one more time the verdict forms and make sure that we feel like they flow correctly and everything like that. But other than that, no objections or other instructions.
If you have a problem with the verdict forms, then I want you to tell me while we're on the record. Okay. And we will go ahead and listen to what the defense has to say. And Mr. Moran, I have marked defense tendered 1 through 7, and I know you gave me another packet that were things that were filed before, which I think are adequately covered in the instructions that I've given. I will mark those all starting at number 8, and I'll do that individually for the record. So defense tendered 8 through whatever you gave me. Do you have anything to say about the instructions that you tendered 1 through 6? And you don't have to if you don't want to.
I don't know. 1 through 6. I've got.
No. So I gave you things that I've already numbered 1 through 7. One pack of 1 through 6. This is stuff we talked about last night. And then we're going to talk about 7 because there's so many different versions of 7. We're going to talk about that separately.
Judge, I don't know how many files I've got now, but what I have here looks like your handwriting. Defense tendered 1, 2, 3.
Okay, there should be
4.
another. It should be. Well, let's talk about 1 through 4, and then we'll talk about the other ones.
And then I've got another pile that's got instructions: defense 7A, defense 7B.
We're not talking about 7. Let's talk about 1 through 4. Is there anything that you want to put on the record?
Yes, with respect to defense tendered 1.
Okay.
It's marked defense tendered 1, handwriting, capital B, lowercase t. This is the defense effort to put human remains protection dogs in their proper context. This is a super controversial issue. It's being heard and moving towards resolution across the country. The problem is when these dogs are treated as definitive substantive proof, there's a dead body in a location. As the court's well aware after having litigated this, that that's not the case. These dogs are allergic to fingernails, hair, blood, things from live humans. The problem in the hands of the jury without proper instruction is that folks will think that humans or dogs don't lie, assign special credence to the animals, and decide cases that because a dog wouldn't lie to us, the dog said there was a dead body here, that there must have been a dead body, and in this case, that would mean a dead body in Mr. Redwine's house and his truck, despite the fact that, as has been testified to for days and days now, innocent remains that fall from live humans cause dogs to indicate. In this case, we had vastly more false alerts or alerts where no evidence was derived than anything else. In fact, I can't think of a single thing that a dog alerted to that led to any substantive proof. That's why we're asking the court to instruct the jury that they need to carefully consider this in its proper context, that as even the state's witness was testifying that these dogs should be considered tools and not substantive, definitive evidence that there's proof a deceased human body was present in less than course, an actual body is discovered, and that was obviously not the case. So I'm happy to work with the court on this instruction. Your Honor and I were here until, I think, 8 o'clock last night.
And I was here longer.
I finally walked through the dark hall somewhere around 8. You know, I know that Your Honor's been working hard on the instructions, and that we're a little pressed for time this morning, but I'm happy to work with the court and counsel on honing this and crafting it in a way that would satisfy everyone. But I think just getting rid of this altogether creates a really dangerous situation, and I have reason to believe that because of all of the challenges nationwide and the lack of standardization with respect to these animals, that there is going to be higher court rulings on this issue coming to a courtroom near you. So I would request that we treat it with the caution it deserves. This is our chance.
All right, Mr. Champagne, did you want to respond?
Judge, we do object to this defense standard 1. It's our position that this unduly highlights that particular set of evidence. It's argumentative and inappropriate for court instruction to the jury on that topic. I can give more detail if you like.
I'm going to not give defense standard number 1. I believe it's argumentative. It's something that counsel can make an argument based upon the evidence at trial. During closing arguments, I'm not going to instruct if there is a defense theory of the case which will be given. And it unduly highlights the dog evidence. There's plenty of evidence the jury can decide what way to give the dog evidence if they want. Defense number 2, Mr. Champagne. I'm sorry. Number 2.
Judge, can you comment on number 2?
No, I have said Mr. Champagne didn't answer.
That's okay.
Mr. Moran.
Your Honor, this one addresses the unconscious bias that we do not want in the deliberation room. I'm frankly sort of surprised that progressive prosecutors would object to this. This is a problem in our country that we are growing in our understanding of, and a juror back there who's experiencing people suggesting that decisions be made based on stereotypes, attitudes, or preferences that people may consciously reject, but may be expressed without conscious awareness, control, or intention, that they're not armed with this instruction is a real problem. I think that that problem is exacerbated by the fact that we tell people to base this decision on their experiences in life, which is, of course, something that needs to happen and is an appropriate part of deliberation, but not if that experience in life is an expression of unconscious bias. And I want to arm a juror who's recognizing that happening with this instruction. It embodies a higher calling of citizenship in this country, and this is the type of thing that we need to move away from, or decisions being made without awareness of that bias. It's something that this country needs to move away from. This instruction helps in that regard, and as Mr. Champagne was saying yesterday, he may believe this on a personal level, but doesn't think that a jury should be instructed this way is distressing. This is something that we should be aware of and incorporate into deliberations and decisions in the courtroom. That's to have intended to.
I'm sorry, I interrupted.
It's something you should be aware of and incorporate into deliberations and decisions in the courtroom.
We'd ask to provide defense tender 2.
Excuse me. Mr. Champagne.
The people do object, Judge. While I may personally believe these things are good and think we should work towards, I don't think a jury instruction, much like a trial for child abuse and murder, is the right place to bring these issues forward. We object. I don't think it has any basis in law, and it's not proper for court instruction.
The court's going to deny defense tender 2. The instructions already talk about how bias is not to influence the juror's decision. That's already in there. I don't know how one paragraph is going to give jurors any education in unconscious bias that they don't even know they have, and what good it's going to be. So number 2 is not going to happen. Defense standard 3, I don't know if we put this on the record before. It's about unanimous, unanimity instruction. I don't think we did, but we did talk about election. So we probably ought to talk about this also. So, Mr. Moran?
One or the other, Your Honor. I mean, at some point, the prosecution is going to have to identify what the theory of Dylan's death was, and they haven't, and they're objecting to unanimity. So now the jury gets to go back there and decide that we could make this call with you thinking, with there being a myriad of different acts that may have led to the results. So there's just no unanimity required with respect to the actus reus. It's a real problem, and it goes to the heart of protections Mr. Redwine's afforded under the U.S. and Colorado Constitution. So this is last chance. You know, there needs to be unanimity. That is a basic tenet of due process, and failing to have an election or unanimity instruction leaves this jury running wild. They're free to decide this case as individuals, but with respect to guilt instead of the individual basis by which they could establish or find doubt. They're not supposed to have an individually decided mens rea, actus reus, and that's what happens without a unanimity instruction or the election that we've requested. So I'm strongly urging the court to provide one of these.
All right, Mr. Champagne.
Judge, thank you, and respectfully, the case is on point. People v. Archuleta, 467 P. 3rd 307. People v. Hansen, 928 P. 2nd 776. Direct quotation. And people versus Wester Gravel, Gardvelle, 465 P. 3rd 570. Unanimity is generally required when we're talking about numerous sets of facts, such as a pattern of child sex assault or numerous sets of specific and discrete factual episodes. As noted in Archuleta from the Colorado Supreme Court, quote, neither a prosecutorial election nor a modified unanimity instruction is required. However, when a defendant is charged with engaging in a single transaction criminal conduct, and the prosecution proceeds at trial on that basis. That's exactly what we have in this case. We don't think unanimity nor election are required.
Okay. Your Honor, before we move on from this, they haven't done it. They didn't do it in opening. They're not doing it now. They haven't ever told anyone how this child died. There's some loose suggestion of blunt force trauma. There's discussion of cut marks on the child's skull. This is a huge problem.
All right. Court is going to deny defense standard number 3. I agree with the prosecution. This is a hugely circumstantial case. What exactly happened is unknown, and I think that's an area for argument. Unanimity deals with when you have various theories that the jury could accept that have been presented in evidence, which has not happened, and we don't think it's appropriate to give. Number 4 is the mere presence at the scene without more is not sufficient to establish criminal liability. I really don't want to hear any argument on this one, just because I think that the elements and the instructions totally cover what the jury can consider and not consider, and I'm not going to give number 4. Number 5 should be incorporated in 7. It was the theory of defense destruction before I went through and made all the additional, well, until I got all the different versions of the theory of defense. And number 6, I'm not sure that you have this.
Your Honor, I don't have 5 or 6, and I think it's not a good idea to move on from 4, especially considering the refusal to give unanimity.
Mr. Moran.
On 3 to move off from 4.
Number 4 is simply mere presence at or near the scene of a crime without more is not sufficient to establish criminal liability. That is true, and that is adequately covered in the instructions as the burden is proved. What has to be proven? We're moving off of number 4. Number 5 is covered in number 7, is what I'm telling you. I know you don't have it in front of you, is what you told me. You have it there somewhere, because I gave it to you last night after you left. But I know you have a lot of different pieces of paper.
You gave it to me after I left.
I left it on you, too. I left it on the table. And it was your initial theory of the defense instruction, which is incorporated in number 7, is what I'm telling you. That's why I don't particularly think we need to talk about it, because we're going to talk about number 7 in just a minute. So that gets us to number 6, which is, in order to convict the defendant of child abuse resulting in death, you must unanimously agree that the defendant committed the same act or acts, or that he committed all of the acts alleged. Which goes back to unanimity. I'll make more argument on 6. Let me see what do you want to see it? Yeah. You have it, Mr. Sheehan. And I put them both on your desk.
I'll take a look at the copy. I think it's kind of the same problem. Right. There's lots of pieces of paper.
Okay.
Judge, I mean, as you can see, there are several piles here, but
I'm not criticizing you about it. It's just, I know it's confusing. But you have it in your hand right now. Is there anything you want to say about it?
yes, give a unanimity.
That's right.
We need a unanimity instruction.
I'm going to show it to Mr. Champagne. And then I need that back when you're done, Mr. Champagne. Thank you. Anything you want to say?
Judge, it's the same record I made just a moment ago. We don't have a situation where we've got multiple different sets of events. We have one single unified event, and therefore unanimity is not required.
All right.
So just to make sure that we're constitutionalizing this, we're offering that the U.S. Colorado Constitution, Article 2, Section 1625.
Okay. For the same reasons, I'm not giving number 3, I believe. I will not be given number 6. Okay, number 7, you should have, and if you don't, I'll make another copy of it. 7A through 7G, let's see. 7G. 7A is the one that we talked about yesterday, that we initially talked about putting into the instruction packet. And that is currently in the packet of all the instructions that you have, and I'm willing to swap this out if everybody. Well, I'm willing to listen to it and perhaps swap it out. The very first one, 7A, is one that if I was going to give something, I believe Mr. Moran wanted me to take. I actually had something a little bit more in there, and he asked me to take out a paragraph. So there's all sorts of various versions, Mr. Moran. I don't know what you want to say about which one you want to give.
7A, but as has been previously noted in this instruction conference, I was here until 8 o'clock. Your Honor was here beyond then. I repeatedly sent efforts at meeting the needs that had been expressed in a limited way. Yesterday when this came up, yesterday when we were discussing the defense theory instruction, I thought to have input from the prosecution about their complaints. I think it's just a generalized complaint about providing a defense theory of the case instruction. I was here willing and ready to work with Your Honor to hone this and make it look how the court and counsel would want it to. The way it's written by the court, I don't know if we've got the version in here that we changed. I mean, the first iteration talked about how the defense counsel was saying that there wasn't enough blood to test in the living room, which is hopefully not a point that we ever conveyed to the jury. So it moved into a different iteration that I think is like the Saturday Night Live version of the defense. Like this looks like a skit rather than what we're trying to say. I know that Your Honor expressed some concern that 7A was a little long. That, I think, is a matter of course when you're dealing with a case that has been going since 2012 and where we spent a month presenting information to the jury. I filed, I think, 5 different versions of defense theory of the case. Didn't hear anything from prosecution or Your Honor. The 7, as it currently stands, that I believe is in what Your Honor intends to divide to the jury, is the first sentence and last sentence. So I think the last sentence is one that Your Honor wrote, but it cuts out all the rest. And I think that's a real problem with the amount of information this jury's been provided, that the defense theory of the case instruction is so little down.
I would point out, now that I'm looking at it, 7B was the instruction that I initially offered to give to the defense, but they wanted me to take out some little paragraphs. So if you want to comment on that, you can. If you don't want me to, you won't.
It's tough to comment on that without feeling like I'm going to get yelled at. It excludes the critical information about animal damage to the skull and the bones of the child. I mean, like some of the most critical evidence in this case. It excludes discussion of the dogs, which is the absolute only way the government puts a dead body in Mr. Redwine's house. The exclusion of that critical information and inclusion of the stuff that we have tried to present and put in its proper context, like the Chiquita banana sticker. We do not mean to reduce our defense to the banana sticker in a bag, or that made it onto Dylan Redwine's shirt. I mean, it's like a caricature of what we've been working on for years now. So I'd request that some version that discusses the photographs, that the DNA is in a quantity, at least, that is unsurprising where humans live, doesn't prove a violent crime by itself, that the animal damage is uncontroverted, that human remains detection dog indications are not evidence of death, only that human remains are present, because we are all shedding human remains throughout our life. That the scent identification lineup was conducted by an uncertified dog. I mean, what I've included in here is facts beyond controversy. With the possible exception of law enforcement not adequately developing exculpatory evidence, but that was the one part that the court expressed a willingness to include. But our defense is not just taking exception with the failure to develop exculpatory evidence. There's more facets to it that are included in my efforts at working with the court and the government to create a defense theory of the case instruction that adequately conveys what we've provided the jury.
All right. Mr. Champagne?
Thank you, Judge. The case on point here is People versus Weiss, W-E-I-S-S, 717 P. 2nd, 511 from the Colorado Supreme Court from 1985. The theory of the defense instruction should be brief, general, and instruct the jury on the legal effect of the explanation. Improper emphasis on particular facts is not favored. And an argumentative manner allows justifiable refusal of the court to give such an instruction. To be frank with you, I think probably the best version that the defense has presented is 7G, the very last one, because it does not overly emphasize the facts for the jury. I mean, we always have to consider that this is an instruction of the court being given to these jurors. And when we start getting into detailing of specific facts, as Mr. Moran has proposed, it begins to appear that the court is endorsing those facts, so there's conclusions regarding the facts that the defense has listed in their instruction. 7G basically just says that they have no burden, that Dylan Redwine left the home on the morning while his father was out running errands and was at work. So I think 7G is appropriate, and I think 7A is appropriate, but I think everything else between them unduly emphasizes the facts that and characterizes those facts in a manner that's favorable to the defense, which would be improper for an instruction from the court.
Okay, the court is going to, well,
If they're not objecting to 7G, we'll take it. I mean,
I'm getting there, okay? First of all, the court would like to point out that 7A came from what I provided in 7B because the defense preferred that over anything else, preferred 7A with less information over 7B, so that's why 7A was given. I am willing to give 7G. I don't have a problem with that. I think the rest of them are very argumentative. They're not brief. They are emphasizing certain parts of the evidence. It doesn't deal with legal theories, and we will replace what I have in there as number 7 with 7G, and that will slow us down a little bit, but that's okay. So with that,
I'm sorry, Judge, I have a couple things I just need to put on the record as well.
okay,
Relating to instructions.
and that's fine. I want to get done with. Okay, that is somebody's film equity, I guess. Is yours on? Yeah. Okay. That's okay. We haven't done it before. We're going to have problems. Mr. Moran, so we have the ones that you want tendered. I'm going to change 7. Anything else you want to put on the record about the instructions or the verdict forms?
Your Honor, as I understand what the court is directing us to do is to not go through each of these. I have provided defense tender jury instructions.
For the record, it was a packet that was handed to me in a manila folder this morning, and it appears to be the same as what was filed by the defense, I don't know when, quite a while ago. Is that correct, Mr. Moran? And you can look through there, see if there's anything else that you think, but
there may be an additional 1 or 2. I don't think there are many. But rather than belaboring all of this, because there are 35 pages of instructions here, the document goes pages 1 through 36, but 1 through 36 is a blank page. So 1 through 35, it incorporates the legal bases for the instructions requested on most of them. So adaptations from Colgi, taking things from criminal rules of procedure. There are case law citations.
Hold on just a second. I know that's all there. That's part of the record. I've looked at all the ones that have been provided previously, and I know I asked you to do this so we'd have it all in one spot. My question is if there's anything new that I haven't looked at. And that's what I need to know.
With the number of piles of instructions, I couldn't say.
All right.
I do not think so. The difference is that the one that was provided today has citations. I'm doing that because my understanding is that Your Honor does not want argument on all of these, that the legal bases will be made part of the record, and that's they're included here. Unless the court wants any further record,
only if there's something in there you think that we haven't looked at. I mean, because I don't know. It was just given to me, and I haven't compared it. So, Your Honor, I'm giving you. I mean, you've been looking through them. I know that, and I know it's difficult on you. But, this is the instruction conference, and so if there's anything specifically that stands out to you, just go ahead. If not, it's part of the record, and I will deny it.
My impression is that they're going to be denied, whether I make a lengthy record right now or not.
I understand that, and that's probably correct, unless you talk me into something, which probably isn't going to happen because hopefully they're all the same that you gave me before. But I'm giving you the opportunity if you want to make the record about anything specific.
Judge, I would have to go through all of them.
All right. That's fine. Mr. Champagne.
Thank you, Judge. Just a couple of quick points. The instructions with citations from defense counsel, as he noted, and the court noted, were submitted months ago at this point. I believe that was at the end of May. And the court has had the chance to review those, and we've had discussions about those last night. at the preliminary conference today, this morning at the conference as well. Many of those instructions are based on opinions that the council has selected. I did want to cite a case I think is important on that topic. It's called Evans versus People, 706 P. 2nd, 795, Colorado Supreme Court, 1985. Quote, trial court's use of an excerpt from an opinion in an instruction is generally an unwise practice. And it goes on to talk at length about how opinions and jury instructions have very different purposes. To take a quotation from an opinion and making a jury instruction is simply not a wise thing to do. Many of the instructions offered by the defense fall into that category. Others make modifications to the closing instructions, which were very recent. I think 2016 is when the Colorado Supreme Court Committee redid the closing instructions with great detail. It's a many years-long process. To make modifications to the closing instructions is probably also an unwise practice. There were a couple instructions that defense withdrew that I wanted to make sure that we got on the record this morning. The original packet contained an instruction relating to impeachment of a witness with a prior inconsistent statement under 1610-201. It's my understanding specifically that defense counsel withdrew that intentionally and voluntarily last night at the preliminary conference and has not submitted that today for consideration. There was also discussion at the preliminary conference last night about instruction number 6, which is the limiting instruction, and the outcome of those discussions last night was an agreement by counsel specifically to number 6, in which this was negotiated language that they have agreed to, and both of those things I think needed to be on the record here today.
Okay, thank you. And Mr. Moran, you've had more time to look at the instructions you provided in the packet. Anything you want to say?
Yes, please.
Go ahead.
So I think it probably makes sense as I go through these to number them, that they'll make it.
Well then, all right. Hopefully they're all in the same order. Before we begin, I mean, one of these is, all right, number 8 is something that would have happened days ago at the very start of the trial. So that's number 8.
Okay.
Number 9 is your version of what the elements are and the charges are separate, distinct.
I'll rest on, we prefer that one. I think it's better explained this. That's some citations for why I think that's the case.
The next one is number 10, which is, it looks like credibility instruction, which may be a little, not sure if anything's added to it or not. I haven't looked at it very closely.
This tracks the language better in our perspective. We'll rest on the record there.
Number 11 is presumption of innocence and burden of proof
based on
and reasonable doubt.
Based on the Pickering decision cited there, and also this is an adaptation of 304 Colgi, or Colgi 304. Colgi states at the what I'll call preamble that it is supposed to serve as a guide. This, I think, improves upon it. We request this and be provided.
Number 12 is a further definition of proof beyond a reasonable doubt, talking about how high a standard it is.
The reason we believe that it should be separated and presented in this way is based on the cases that come below as supporting authority listed here, diluting the beyond a reasonable doubt standard and putting it in with other legal principles as it stands in the instructions that the court's going to provide. Unnecessarily dilutes it, and we believe that to be a problem under Colorado Constitution, Article 2, Section 16 and 25 in these cases listed here.
Defense 13 is an instruction that I gave as instruction number 21. Number 14 is the written questions from the jury, which I gave. I don't know if it's the exact one, but one very similar.
I think so. So this is appropriately considered rejected. And
number 15 is that charges are mere accusations.
Based on The adaptation, I think that's necessary of Colgy 303 and the Keenan case. I think there's support for having it read this way. The charge being brought by the state and read by the court gives it more weight in the eyes of a juror than it should, and this motion, or this instruction corrects that misperception, so we'd ask to have that provided.
Number 16 was given as instruction number 10. Number 17 was the credibility by showing previous acts of dishonesty.
I'll withdraw this one.
Number 18 was the confrontation by a previous statement, which I believe was withdrawn last night.
Yes, sir. Withdrawn.
Number 19, uncertainty about any terms used in these instructions. I did give this instruction.
Do you know the number? Not off the top.
I think it's near the end, but no, not off the top of my head.
We discussed this next one.
Hold on, do you want the number?
No, that's all right.
Thank you. So number 20, we talked about earlier, that's the mere presence of the crime scene.
The court did not want further argument on this. I have some provided briefly.
You know, go ahead.
The lack of unanimity instruction and the prosecution's case that the isolation of Mr. Redwine's home, I think is going to create the possibility in the minds of some jurors that the fact that Dylan's there at some point, Mr. Redwine's there, means that presence is going to be sufficient to make a guilty finding. So without the presence instruction, with no unanimity instruction, with no election, we're creating real problems, and I believe reversible error. So this might minimize the problem a little bit. We'd ask to provide it. There are all of these cases that I think provide support for giving an instruction like this.
All right, number 21 is the mere suspicions are not sufficient to constitute proof beyond reasonable doubt.
Again, that I think piggybacks really well with defense tendered and then rejected. Number 20, so I'll incorporate my argument with respect to the unanimity election, number 20, and the other similar instructions with 21, the defense tendered 21.
22, I don't know where this actually came from. It does talk about unanimity. It talks about every fact essential to prove the element. I believe these are all covered in the elemental instructions for that to prove beyond reasonable doubt. So,
well, just incorporate the cases cited below it and rest on that. This is an accurate statement of the law.
23 is unanimity instruction that you, I think, we've already talked about. 24 is a similar unanimity instruction that we've talked about.
With both defense tendered 24 and 25, I understand the court's rejecting them. We incorporate previous arguments with respect to unanimity election.
All right, 25, I believe I gave about news coverage. I don't know what the number was, but I've talked about it constantly with the jury not paying any attention to it.
Thank you. I would agree that that one was provided.
26 talks about judicially noticed facts, which there were not any. We came close, but there were no judicially noticed facts.
Withdraw that one.
27 is Mr. Redwine's right not to testify, which has been given.
Further language of this one, but I appreciate the court giving this instruction. Thank you.
28 is that talks about law enforcement officials and their credibility, which I'm not giving. Anything you want to say about that?
Yes, based on the testimony that was provided, the theory or the hypothesis provided by the prosecution is that tie always goes to law enforcement, that if there's a problem that is exculpatory, ignore it and only consider what they did for its inculpatory value. That's placing undue weight and giving more credibility just by function of people wearing badges. So we ask the court to accept this. It would put things in their proper context and give the jury, arm them with what they need to be able to say that law enforcement officials are witnesses just like the rest. And,
law enforcement officers are witnesses, just like this that was talked about on Boyd Dyer, credibility instruction. I think that clearly covers what we need to cover. 29 is the one about vigorous debate, and don't be coercive or threatening to each other while you're deliberating. Anything you want to say about that?
We just want to make sure that folks are armed with permission to prevent jury misconduct. And if this instruction does that, we ask for the exception.
I'm not going to insult the jury by giving this instruction. Number 30 is the limiting instruction, and a limiting instruction you gave us, but we have a limiting instruction, and I think that was agreed to by the parties yesterday by stipulation.
I would not stipulate to that, Your Honor. We provided the court with a description that we think meets the court's previous orders with respect to the limited purpose for which that evidence could be provided. We are not conceding that the instruction as currently written provides proper guidance, follows the court's previous order, incorporates the law of the case properly. There's an expansion of the 404B limited purpose that has happened very late in the game and right before trial. So we continue to object. We think that evidence of the photographs is absolutely radioactive. The court initially allowed it.
I'll change this. I did this for you yesterday. If you want me just to give the very short, limited instruction, I'll give it. It won't be exactly this one. This is what I provided you yesterday that we talked about. So I'm trying to change that one too.
If the court wants to change it to what we're suggesting, which is
no,
adheres properly to Your Honor's original order that the photographs were being admitted based on the heckling that occurred at Mr. Redwine's house by Denise Hess and Kathy Berry. That was the instrument through which the prosecution sought to admit this. They called it the singular purpose for which they wanted to admit the photograph. Your Honor considered, after lengthy presentations and arguments, I think this issue being revisited in motions to reconsider, the ruling of this court was that evidence could be provided to prove that Mr. Redwine had a violent reaction to confrontation by those photographs. This instruction, or the instruction on this issue, does not track with that limited purpose that became the law of the case, which we relied on in preparing the case. It changed at the 11th hour with limiting instruction that was provided to the jury and objected to at the time. I will acknowledge that we didn't object to the one that was filed or that the court put into ISIS in the weeks leading up to trial. But at the time we objected to it, once we caught it, we would ask the court to return to the law of the case, which was created by Your Honor's order on this issue, and to put the limited purpose to paper, to instruction in the way it was provided by Your Honor in the order from, I think, 2019.
Well, I'm sorry you guys didn't read my orders. I told you what I was going to do. I didn't bring it up more than a year ago. Mr. Johnson, is there something else? This is instruction number 6. What did I propose to you?
Yes, Your Honor. I just want to make sure we make a clear record, because last night we did this conference off the record knowing that we would come in. And I agree with the court's characterization. Mr. Moran stipulated this particular jury instruction yesterday. And there is a more simple version the court can give. The single purpose that was granted by the court is motive. The details of how that motive applied were in the narrative of the 404B motion. This could read just simply the limited acts can be considered for motive. That would be fine with the people. The only reason we have this more descriptive instruction is because defense counsel throughout the case has wanted some of the additional language, and also because of the conversation yesterday. So if we need to revisit this instruction, I agree with the court. We can simplify it. However, Mr. Moran should not come in here yesterday and stipulate, and today try to preserve a record on an objection that didn't exist at the time of this instruction.
This is why we don't leave
Hold
it
on.
off the record.
Hold on. Okay, I'm talking now. I'm letting you make your record. I'm letting you do the objection. I was just a little surprised about it. You've made your record. I will give the stock instruction about a limited purpose. If you don't want number 6, that's what I'll do. But you tell me what you want.
This is what I want is the instruction
Between
that we provided
those two.
the court.
Well, the one, which is basically what you gave me. It's from Colgy, but it's I'm going to take it right out of. I'm not sure if it's a different version or not. I guess I will get it. So hang on. Let's go on. I'll do it right now. Go off the record.
Judge, I'm sorry. So maybe some corrections to the verdict form as well, and just some typos.
We'll just get there when we get there.
Okay.
You guys don't have to stand up for me, I'm thinking. So I've just handed you a new proposed number 6, Mr. Moran, which is the straight cold G instruction without the additional paragraph you're asking for, number 30, which just restates what's said above. So which one would you rather have?
I'm only choosing this based on the court denying the one that we've requested. I'm choosing.
I agree.
Okay. And we still object because it should be one or the other. So what I mean is that this instruction number 6, the one that is not the proposed 6, the last 2 sentences provide 2 bases for which the jury could consider the 404B absolutely radioactive photographs. The first sentence, where Your Honor writes, was to allow the prosecution to attempt to prove that the defendant became violently enraged, tracks with the law of the case, tracks with the ruling made at the time that we argued this, that we presented evidence on this. I think it was a 2019 order. It described the one limited purpose that was outside the forbidden inference, and we lived with it. That changed late. We objected to it once we became aware of it. The jury, I believe, was provided with different instructions on how it could be considered. So the proposed 6 at this point, saying you're instructed you can't consider it except for the purpose I told you about, is going to be problematic because to the extent they remember those instructions, they were different. So original 6 is better, but the last sentence was admitted to allow the prosecution to prove motive creates an issue because the evidence as it stands includes a text message wherein Dylan says to his father, it says to his brother, I want the photograph so I can show Dad who he really is, which is an absolute comment on character, and not being careful in how we instruct the jury on this is allowing the prosecution to get evidence that provides information to the forbidden inference in front of the jury. This instruction allows them to consider it. So we're asking the court to adhere tightly to the law of the case. It was considered carefully after evidence provided, arguments made, and that adherence will keep it in a place where the careful consideration that it was given at the time all of that was presented is what gets in front of the jury, doesn't create other issues. So we object to not keeping it to the sentence that starts. The first was to allow the prosecution. We prefer the other instructions that more carefully delineate the law of the case, and we base those objections on Colorado Constitution, Article 2, Sections 3, 6, 10, 16, and 25.
Well, my question to you was, do you want the shorter version of 6 that I just gave to you, or do you want 6 that's in there? We've already talked about what you want in terms of instruction number 30. Are you telling me you want the number 6 that talks about motive and talks about the photographs, or not? It's a simple question.
And Judge, I would like to
I'll let you respond.
In this bargain, I will take 6 because of the rejection of the other.
Okay, they're both marked as 6.
One is proposed 6. I'm choosing 6 as marked.
Are you choosing 6 that talks about
The longer
3
one.
paragraphs? Okay, I'm going to mark this as 6B, tendered by the, proposed by the court as part of the record. So, Mr. Johnson, did you want to say something?
Yes, Your Honor, because I know counsel is creating a record, and I want to make sure it's an accurate record, and we'll look at that later. The people filed a motion for a singular act of other acts of evidence for a singular purpose of motive. The court granted that. The interpretation of motive by defense counsel has been to take particular language from that argument and use it. That motion actually explains that Dylan had requested the photographs before and that the violent incident had come afterwards. The limiting instruction applies to what the court has put here, the photographs and the defendant's reaction. To over-particularize the people's argument and characterize it by the defense inaccurate. The court set a deadline for the contemporaneous instruction. Counsel did not make a timely objection. At the time of trial, counsel made an objection that was overruled by the court. The interpretation of motive is different for the parties, but that was the singular purpose for which the court granted it in both people's request and the court's order. I'm fine with 6, but it should be noted that counsel stipulated to this yesterday, changed their mind today. And then it should also be noted that the people are open to a third option that simply says the reason such evidence was submitted to allow the prosecution to attempt to prove motive. The additional language about violence and rape when confronted by others with the photographs that defendants request. The people intend to argue motive generally at closing argument as well, as granted by the court. So we're open to whichever of those 3 options counsel chooses. But we should not be overly specific based on some language from a motion. It should be the court's order that this is allowed to prove motive, period. And parties can argue with that.
Do you want that changed, Mr. Moran?
Which change?
Where we take the longer version that talks about the photographs and simply say that this evidence was admitted in an attempt to prove motive?
No.
Okay. All right, then we're going to give what I previously put in there. So I'm going to have put 6G, 6B behind number 30.
I just want to clarify the record that the stipulation, to the extent that it sounded like a stipulation in Mr. Johnson's, was not.
I understand that was your position. That's not how I took it. I guess we were all operating late last night, and things were confusing. So that I'm not assigning blame to anybody. So 31 is talking about a unanimous verdict, which we have an instruction about that, but this certainly goes on further, almost inviting a hung jury. So anything that you want to say about that, Mr. Moran?
That the last thing in the world anybody wants is a hung jury, but that is a safeguard that's been built into the American system of justice. Jurors, if they can't agree, have to remain with their reasonably staked out positions. This gives them permission to do it. It's an unpleasant reality with all of the work that's been put into it, but it's one for which they need to understand that they are protected, and this instruction would do it would have to be given.
The instructions I'm giving, I think, state the law appropriately. I'm not giving number 31. 32 is your version of the limited instruction, which is, we're not even going to talk about it. I think we've gone through limiting instructions, all we're going to.
The only thing I'd have to say about this is we're happy to work on narrowing this down. I don't think the court would allow it. This is a description of what 404B is about. And again, we asked for it because we believe this evidence to be radioactive. We spent a week inquiring of people whether they could follow the instruction. They said they could. I think that they should be instructed carefully and properly. This instruction or an instruction like it that we work on together that would do that.
Well, we did work on it together yesterday. That's why we came up with what we came up with. I'm not going to give this. It's way too detailed, too long. It's restating evidence that shouldn't be in here, and you are getting number 6 in the packet. Number 33 is the human remains detection dog, which we've already argued about earlier.
I think we've already discussed unconscious bias. I'll rest on the record there.
That's not what I'm, oh, it is. Okay. So that's number 34. Thank you, Mr. Moran. 35 is the bailiff will now escort you to the jury room, which I gave. Number 36 is a similar, we talked about law enforcement officers. I think the record adequately, we made a record on this on a previous one.
Incorporate the previous record and the citation too.
37 is lessers, and there were stipulations as to what the lessers would be last night, and those have been given. 38 looks like the definition of criminal negligence, which was given, and so that's all of them. So those are the instructions tendered. I will change number 7. And other than that, anything else you want to say about instructions, Mr. Moran?
Judge, we have a further question. The typo on correction.
I'll take care of it in just a minute. I'll get through Mr. Moran first.
No.
All right. Okay. Where is there a mistake in the verdict?
Count 2.
Right.
At the top it says manslaughter committed with criminal negligence.
Hold on a second. Sure. What did I miss?
Child abuse committed with criminal negligence.
Oh, thank you. I thought, you know what, I did see that last night, and I thought I fixed that.
And then, Judge, the only other note I was going to make is the current coaching instructions put an or between the primary count and the lesser count, just to kind of stress that it's either going to be child abuse knowing the reckless or child abuse with criminal negligence. My suggestion again, stated child abuse to the mens rea, that we put child abuse knowing or reckless, and then put child abuse with criminal negligence, distinguish them and add an or. And then on the verdict form 1, I would also suggest adding the or. I just think that the jury didn't speak the time frame at the time and check more than one box.
Yeah, I'm not going to make those changes. I think what I said at the bottom covers it, but I will definitely correct the verdict form. Regarding child abuse.
Okay.
So I think that because it's being provided with knowing or reckless, it's essentially the same thing, same facts as count 1, which is a knowing crime. The addition.
Can you let me do one thing at once? Okay. You can bring it up in a minute, but I'm trying to do something else right now. So, Mr. Moran, you also wanted to talk about knowingly and recklessly, I assume, in the child abuse statute?
Yes, please. So what we've got here is the last chance to fix this without election, without a requirement of unanimity. We won't know whether the jury decided that Mr. Redwine's conduct was knowing or whether it was reckless. The verdicts will be then contradictory, one being knowing, the other possibly being knowing or possibly reckless. So I would ask the court require the prosecution to choose which one. We're now in a situation where the mens rea will not require unanimity. We also have a situation where the actus reus will not require unanimity. That's why we requested and continue to request election, or at least clearing this up with a unanimity requirement provided by instruction. We're doing that under Article 2, Section 1625 of the Colorado Constitution and U.S. constitutional protection.
Well, I'll let Mr. Johnson speak in a second, but I caught that a long time ago. Reckless, however, is basically a lesser included of knowingly. If you act recklessly, you also act knowingly. Therefore, any jurors that only find reckless behavior could find this count proven. It could also find, even if some jurors found it to be a knowing action. And so anybody that finds knowing is automatically finding reckless, so you do have unanimity. But I don't mind changing it with persons. What do you want to say, Mr. Johnson?
Judge, I agree with the court, and here's why. In murder in the second degree, knowingly is applied to causing death. So knowingly is applied to the result. And in child abuse, knowingly or recklessly is applied to the conduct. And that conduct is different than causing the death. So that knowing or recklessly is applied to the conduct causing injury to a child's life or health. So because the mens rea go to different actus reus, there is no conflict. And in child abuse, the result is actually a sentence in cancer, as indicated by the interrogatory and the case law. And so what we have here is a situation where easily, just to use one example, the jury could find that the defendant recklessly caused an injury to the child or knowingly caused an injury to the child that had a different or similar mens rea in terms of causing death. So they're very different crimes in that one has the mens rea to the actus reus, and one has the mens rea go to the result as well. Because of that, there's no conflict whatsoever in terms of inconsistent verdicts, anything presented to the jury.
Well, he's talking specifically as solely the child abuse statute. And so I'm not sure I quite understand your argument, but my ruling is that I don't see it being a problem because the statute talks about both knowingly or recklessly fits the definition. And if somebody finds knowingly, they've obviously found recklessly.
I agree with that as well, Judge, and I think the statute itself is constitutional and appropriate, and it reads that way in the full jury instructions, and so I agree with the court 100%. All right.
But if you find recklessly, that's not necessarily knowing.
Correct, but all you have to find is recklessness.
All right. But we stand in our
I understand that. We're
motion for
I understand.
election.
So we're going to have a short recess then. While we change number 7. I am going to give the instructions 1 through 26 with the change to 27 and or with the change to number 7, excuse me, with the change in the child abuse verdict form. So you guys can do what you want while we take care of that. We're in recess. You don't have to stand up for me because I'm going to be in and out of here.
Becca?
So this one I need to print also.